Hello, everybody. Okay, today we are going to be talking about 10 common errors, 10 mistakes you make while purchasing a property or a land. So, if you're new on this channel, I am Dr. Blessing Joseph and you are with Victoria Legal. So, please, if you're yet to subscribe, do so immediately and share this video to everyone around you, because I don't want to be hearing things like I bought land in Lagos and my land was grabbed. I bought land in Port Harcourt and my land was grabbed. Oh, you cannot buy land in Abuja. No, you cannot buy land here. You cannot buy land here. Go and buy land in your village. No. Gone are those days. This video is going to be teaching you about those simple errors, those common errors you find amongst us, why you lose your land, why you start having the notion that you cannot buy properties in some certain areas. No, we're going to be tackling all those problems in this video. So if you're yet to subscribe, please do so immediately. Share this video to everyone and don't go anywhere. We'll be right back. 10 common mistakes you make while purchasing a property or land. Okay, number one mistake here is buying land as a couple. Don't get me wrong, I don't mean it is wrong or it's erroneous to buy land as a husband and wife, or in a relationship you buy land together. No, you can get any property of your choice as a husband and wife. Yes, you can. But look at the error here, and it is common. The problem here is that a lot of persons find themselves making the same error. They buy properties, they buy land as Mr. and Mrs. Okechukwu Benson, for an instance. I hope there is no Okechukwu Benson out there. Of course, there can be anyway. But please, Mr. and Mrs. Okechukwu Benson is totally erroneous. I was thinking many of us would have woken up from this whole nightmare, or a lot of lessons, a lot of cases we have, reported cases in court concerning acquiring properties as a couple, Mr. and Mrs. No. Please, when it comes to acquiring properties, when it comes to legal issues, the law sees both parties, that sees the couple as individuals of their own. You both have your own things, you understand? This is not the religious aspect here or the spiritual aspect here. No, we're talking about the legal aspect here. So if you're getting property, if you're buying any land or you're buying any property anywhere as a couple, please note this: Mr. Okechukwu Benson and Mrs. Felicia Benson. Put your first name first, followed by your last name, which is your surname. So, Mr. Okechukwu Benson and Mrs. Felicia Benson. It shouldn't be Mr. and Mrs. No, cut that crap, okay? Second error we'll make here is why purchasing family property. You will see some persons, they want to get a family property, maybe a family belonging to the God's Power family, and you find yourself buying this property from just one person, just one member of the family. No. If you're buying property that belongs to a family, you must get the consent of the family head and other principal members of the family. Not just to be bought from an individual. No. It shouldn't be a single person. It should be the family head and the principal members that are selling to you as the buyer. If you obtain any property that belongs to the family without the consent of those persons that I've mentioned, then you find out that you have committed a grievous error here, because you can lose that property. Yes, you can lose that property at any time, because you can't give what you don't have. Since the family owns the property, the family should sell to you. So these are few errors we find ourselves making. Number 3 error here is buying or acquiring a property without involving your lawyer. You find scenarios like, hey, doctor, lawyer, barrister, counsel. I just bought a property at so place. I need you to help me with the documentation, help me prepare a deed of conveyance. I'm not saying it is wrong to do so. No, of course, it has to be a lawyer called to bar, to the Nigerian bar. It has to be a lawyer called that can only, it's only a lawyer that can prepare a document, a legal document for you in this country. Yes, so I'm not saying it is wrong to involve your lawyer, no. But the stage, the time in which you involve your lawyer is what matters here. And a lot of persons make the same mistake. You find them bringing the lawyer at the dying minute, at the stage of just preparing the documents. No. Please get your lawyers involved from the first stage, because there are lots of things your lawyer has to do for you, not just preparing the document here. Your lawyer can help you make an intense investigation. The lawyer will have to investigate the title of the property for you, whether the person selling this property to you has a valid title to transfer ownership of the property or the land to you. It is the duty of your lawyer to find out, to investigate further, to find out if this property is in dispute. Do you understand? So there are several things in which the lawyer will check for you. The lawyer will check the survey plan. The lawyer will check the signature of the other property. There are so many things, and we're coming down to that. So please involve your lawyer at the appropriate time, from the beginning, from the first stage, because there are several stages in acquiring property. Okay? The next one is buying property with the name of your children or your child, or that's an underage child. Buying property for an underage child. In this part of the world, I'm not saying this is wrong to buy property for maybe your 5-year-old child or your newborn child. You're buying property in the name of your newborn child. No. But do you know that if you acquire property with the name of with the child's name alone, that is totally wrong. And we find ourselves making the same mistakes. A lot of persons are still making the same mistakes in this era. You can lose that property, okay? Quote me, you can lose that property. If you want to buy property for your underage child, the child below 18 years, that's what I mean by underage. A child below 18 years, because it's presumed that this child is not capable of owning property. It's assumed that this child is not capable of knowing what he or she is getting involved in. So if you want to acquire property for your child, an underage child, please do so by involving yourself. Also put your name. Also add your name to the document, not just the name of the child. Add your name to the document. It is paramount, very, very important here, okay? Another error that is common here in purchasing a land or a property is buying your property, then abandoning it for a long period of time. Oh my God, you find a lot of persons doing this. And in fact, not only does it attract land grabbers to your land, you also can lose your title, your ownership, even if the purchase is very genuine. If the purchase is very genuine, you can still lose that property, okay? So this is a way of you not losing your property. Don't abandon your property for a long period of time. Yes, the law stipulates 12 years. That after 12 years of non-possession of your property, it can be deemed that you have abandoned it and someone else can take possession of it. Yes, but still, that 12 years is just in the book. We're talking about what's practical here. What is practical here? From 5 years, someone else can take your property. If someone stays on your property for 5 good years, someone else stays on your property for 5 good years without you opposing it. Without you challenging such possession, my dear, it is deemed that you've lost your rights to that property. So please avoid making such errors. That is why I advise my clients, when you purchase property, when you buy property, whether from a real estate company or wherever you're buying property, please, if the land doesn't have fence to it, fence it. Put a gate to it. Show possession. If it's to start planting on it, start planting on it, start farming on it. Let everyone around there know that this property has been possessed by you, so that you do not face the issue of abandonment of your property. Someone else that knows it better than you can, take over that property from you. So if you don't want issues of abandonment, please, please, and please take full possession of your property. We're tired of seeing bushes. We're tired of seeing abandoned properties. We're tired of seeing undeveloped land. So please take possession and develop your property, okay? Another error here is the issue of erroneously believing that the Nigerian police has jurisdiction over land disputes. No. A lot of persons will have issues of encroachment on their land. Then you see them running over to the Nigerian police, running over to the police station, reporting, I have such person encroaching on my land, such person wants to take over my land. No, police cannot do anything for you. The police cannot do anything for you. They don't have that jurisdiction over land disputes. They don't. It's only the Nigerian courts, okay? Only the courts, the relevant courts with the appropriate jurisdiction, that's the high courts for now, can entertain such land dispute matters. Okay, so don't waste your efforts, don't waste your time, don't stress yourself running over to the Nigerian police. Get yourself a competent lawyer that would help you pursue your matter, that will help you take up your matter to the relevant court so that you can claim back your property. If you run to police will only get involved whereby you have issues like violence, maybe at the process of dragging your land, threats, assault, or you obtain the land, the person who sold the land to you was fraudulent, or there is fraud in the purchase. That's the only time the Nigerian police can get involved. So any other time aside this, as regards land disputes, issues pertaining to land, please get that off your chest. Nigerian police cannot help you. You need a lawyer. That's what you need. Number 7 error on my list here is making payments of your land or your property, to be it maybe the land agent or one of the family members of the seller. You would hear things like, I'm the brother of the seller, I'm the uncle of the seller, I'm the mandate of the seller, I'm the one who is in charge of the land, so you can pay to my account. In this era, in this modern day, please, no, you cannot pay to such accounts. Pay only to the landowner, and make sure you identify the owner of the land. Make sure you are certain that the person selling to you is the same owner of the account you're paying to. Don't pay to any brother or anything. Don't pay to any land agent. No, pay only to the person you are purchasing the land from. That is the only account you should pay to. The only instance where you can pay to another account is if that person possesses a title. You understand? Possesses a title to collect such purchase amount on the landlord's behalf. You understand? Maybe there is a, there is a power of attorney that has been issued to the person, to the land agent. That is the only instance you can pay to the land agent. And you have to go through the power of attorney very, very well. Make sure you scrutinize it and you see that such donee has the power from the landlord to receive the purchase price, the purchase amount. You must be certain. So don't just waste your money, because tomorrow, my dear, they will deny you like Peter. They will deny you the way Peter denied Jesus Christ. Do you understand? So don't throw away your money, okay? Pay only to the seller's account. Another common error here is, this should be my number 8, okay, on the list, is failure to obtain a documentation. That's failure to prepare a documentation to reflect this purchase, this transaction, this contract, okay? It's the duty of a lawyer, get a competent lawyer like myself, okay? Get a competent lawyer to draft a deed to reflect the sale. If not, such sale will not be valid. Yes, such sale will not be valid. It's the duty of your lawyer to execute, that's to prepare, to draft a deed to reflect the sale. And there are certain important clauses that must be in this deed, be it a deed of conveyance or a deed of assignment, depending on your jurisdiction. That is why I said get a competent lawyer. A competent lawyer will know and will let you know the particular document to prepare for you. Okay? 1, the lawyer will look at the parts, the introductory parts, identify the parties. Be sure that, okay, the parties, that's the seller and the buyer here, the vendor and the purchaser, you understand, those are the terms that you usually find that are used in a deed, okay, a deed of purchase. So you would see the lawyer has to identify the parties involved. The next part is the recital. The lawyer has to trace the history of the land. How did this owner, how did he come about the land? How did she receive the ownership? How was the ownership bestowed on him? The history of the land has to be traced. Then the last part, which is very, very important, the executory part. It has to be executed. It has to be signed by the vendor, that's the seller, and the purchaser. It has to be signed by them. It has to be sealed and then delivered. These two parties must also have their witnesses. So that is why the lawyer is very important here from beginning. If you can remember one of the mistakes I mentioned concerning involving your lawyer at this last stage of just preparing your document. No. If you get a lawyer involved from the beginning stage, the lawyer will be able to have a good background to this purchase. Then at the ending part, which is very, very important, because if the lawyer misses any of these parts, your document might not be valid enough, okay? So for you to get a good, valid document, the lawyer has to be involved from the beginning, so that at the ending part, the executory part, if it's a family land, the persons to sign it, the lawyer knows how to draft that part, okay? It must be executed. It must be signed in the presence of witnesses. Yes, so this takes us down to the next one, the next mistake a lot of persons find themselves making. Failure to obtain, that's failure to retrieve the old document, the old title document from the seller. A lot of persons will just pay for land. Okay, lawyer, cancel, come and prepare this document for me. The lawyer will tell you, okay, give me your survey plan, prepares a document for you, you go, and that's all. No, please. A lot of persons they make the same mistake. They make the mistake too much. It's too much. That's why I'm pointing it out. Make sure you get the old document, the old deed. That is the deed between the person you're buying from, the seller, and his own predecessor, his own seller. You understand? Get the documents existing between the both of them. You should have them. If there are 3 copies, please obtain the 3. 4, get them. Get the whole copies. The seller doesn't need it again. The seller does not need the document again. So it's supposed to be in your own possession. You're buying it, everything that has to do with the land, take it from the seller. Don't forget this. You thank me later for it. Another error we make here is leaving your deed dated. You understand? That is why I tell my clients whenever I prepare a deed for them, I tell them, and this is the last error, okay? I tell them, please do not put a date on this deed. At the second page where you see the deed, this deed of conveyance is dated a dash day of dash 20 this or 1990 this. Please, the lawyer knows what he or she is doing, okay? We know what we are doing. We know why we don't put dates there when we are typing it for you, when we're preparing it for you. We know why we leave it undated. Okay? We know why. So please don't help by putting dates. Don't put date on it. Leave it undated. You know why? Once you put date on it and you take your document for stamping, you will start paying. You start paying for stamp duties from the date that is being placed on that document. So don't put any date there till you are ready for stamping. You are ready to pay your stamp duties. So please leave your deed undated. Even the person signing on your behalf, those witnesses and co, please, you don't want to find it in any of the